Good afternoon, everybody, and thank you for joining the Legal Aid Foundation of Los Angeles for this special consumer webinar on understanding home rebuild contracts after a disaster. We hope this webinar proves useful to you in navigating your home repair or rebuild contract after the wildfires and protecting your rights throughout that process. My name is Nisa Sethi, and I'm a managing attorney with the Pro Bono Disaster Response Team at the Legal Aid Foundation of Los Angeles, also known as LAFLA. LAFLA is a nonprofit law firm that's been around for almost 100 years with the mission of helping low-income communities across the greater LA area through direct legal services, systemic advocacy, and community education. In addition to our full range of free civil legal services, we also have disaster-specific clinics and workshops and provide legal assistance to disaster survivors in areas such as FEMA, public benefits, and tenants' rights. For more information about our organization or services, please visit our website at lafla.org. I'm pleased to announce that this webinar has been co-sponsored by the Altadena Town Council, the Palisades Long-Term Recovery Group, the Eaton Fire Collaborative, and the law firm Cox Castle, which will be presenting our webinar today. Before I hand it off to our presenters, Morgan Werledge of the Altadena Town Council would like to say a few words. For background, Councilmember Werledge serves as the chair of the Rebuilding and Infrastructure Committee of the Altadena Town Council. He's also an Altadena resident who lost his home and work studio in the Eaton fire. Following the disaster, he became a neighborhood block captain with Altogether, where he co-authors the biweekly newsletter. And then finally, he's also served on the Eaton Fire Collaborative's Rebuild Committee. So I'll pass it to Morgan.
Thank you, Nisa. Thanks everyone for being here. And as Nisa mentioned, my name is Morgan Werledge. I am a committee member on the Altadena Town Council, and I also chair the Rebuild and Infrastructure Committee for the Town Council. Navigating the rebuild process is one of the most critical challenges that's facing our community. And the contracts that we sign are the foundation of that journey. So whether you're reviewing an initial bid or finalizing your plans or hiring a contractor, understanding your rights, the terms, and the obligations is essential to protecting your home and your investment. So I myself, as Nisa mentioned, I'm rebuilding. We're currently in the middle of framing, and apologies because I actually left my site. And so I'm doing this from the car. But we're right in the middle of this process. And like so many of you, I really started out knowing nothing about how to build a house from the ground up. It's an intimidating process. And every day it seems like there's new challenges that come up, new decisions and new unknowns. During the course of construction, one thing is certain, that changes will happen. So having something in writing is a must, and having an understanding of building contracts is something that becomes vitally important. So I'm incredibly grateful to Nisa and to LAFLA for supporting us and our recovery. And I'm grateful for Cox Castle for this presentation. Their teams are here to share vital expertise on what to look for, what red flags to avoid before you sign a contract. So before we begin, I just want to give a brief disclaimer from the Town Council that while we're proud to facilitate and host educational resources, like the seminar, the Council does not provide legal advice or formal legal endorsements. The information shared is for educational and informational purposes, and we encourage residents to consult qualified legal counsel for specific contract review. So with that said, thank you all for being here. And I'll turn it back over to Nisa. Thank you.
Thank you so much, Morgan. As I mentioned earlier, this webinar will be presented by the law firm Cox Castle, who agreed to provide this community education on a pro bono or free basis. So we're very grateful for their time and their expertise that they're sharing today. Just a quick background on our presenters. Tyler Dawkins is a partner with Cox Castle with significant construction law expertise. He's negotiated and drafted construction contracts for a range of different rebuilds, and frequently advises on matters related to construction. Robert Shaya, also a partner with Cox Castle, is among Orange County's leading construction litigators whose practice focuses on all types of construction related disputes. Jason Adams, another partner at Cox Castle, has extensive experience with construction law, having represented a range of different entities through all phases of the construction process. So we are incredibly grateful for this team. And then I just wanted to go over a few admin items. First, thank you to attendees for being here today and for submitting your questions in advance. Our presenters aim to address those questions throughout their presentation today. But in the interest of time, we're not going to have a live Q&A session today. I also just wanted to note that this presentation is being recorded, and we will share both the recording and the PowerPoint with all of those who attended, and we'll likely also post it on our website. That's it from me, so I will let our lawyers from Cox Castle take it from here. Thanks again.
Awesome. Thank you so much, Nisa, and thanks to Morgan as well. And before we get started, just want to thank both of your organizations and the other co-sponsors of this event for all of the incredible work that is going on, trying to help folks navigate this very difficult process. As Morgan was mentioning, it's not an easy road, and especially if it's a new road that you've not traveled before, trying to deal with design and construction and everything that goes with it can be overwhelming at times. So we're proud to be a part of this and grateful for the opportunity. And hopefully everybody who's participating is going to get something useful out of this. There's a ton of information to get through. So we're going to try to do our best to cover the sort of steps along the way of a rebuild in a way that gives everybody enough framework to go at these problems with some understanding of who does what and how it's supposed to flow. There's undoubtedly going to be individual questions and issues that arise before and during your unique projects, and we encourage you guys to reach out to the various resources that we're going to share with you along this presentation to get more information on your specific projects. So, Giselle, if we can go to the next slide. So this is kind of our overview, our pathway of the elements that we're going to be working through here today. The vast majority of the presentation is really going to be focused on the construction piece. But we want to make sure that we're giving enough of a high-level understanding of this process to everybody so that no matter where you are in your project and process, you can follow along and get something out of this. So the first, and we can go to the next slide. So at a high level, at the very beginning, we need to establish a budget and a timeline. So there's a number of ways in which we can look to various sources to establish a budget for your respective project. A lot of these projects we realize are going to involve insurance proceeds and insurance resources, and we're going to get into that in a little bit more detail in a minute. Jason's going to speak to that, and he's a insurance guru, so we'll let him handle that. But at the outset, we need to understand the framework of what are the dollars that we're really working with. What are we capable of building with those dollars, and what's the bucket, right, that we can draw from. There's a few options and ideas about finding those estimates and budget numbers through here. Early involvement of a contractor and early bidding on early design documents. Sometimes an architect can help provide rough upfront ideas about how much a project may cost. And then, of course, in working with the insurance process, you should get some sense of not only your budget, but potentially the total cost of the project that you're facing. The last bullet point on this slide, and that's also on the next slide, is to include a buffer, right? because, as Morgan mentioned, there are going to be things that come up that you didn't expect. There will be changes. Changes will occur. That's an inevitability in construction. So you always want to have some set aside, some contingency or some buffer to be able to fund things like that as they come up. So that's an important piece. We can go to the next slide. So aligned with the idea of project planning, we also want to think about time. So time is also going to impact the budget. It's going to impact the dollars. It's also going to impact how long you are displaced or in one place versus another. And we need to have, just like our budget, we need to have a realistic idea about what the time is going to be. How long is this really going to take? And just like with our budget, as I mentioned, things are going to come up. Things are going to change in your schedule and your timeline. Things that weren't expected to take this long are going to take that long or longer, right? So we also need to build in a kind of contingency or a buffer when we're thinking about duration. These few items on the slide are just elements of the project timeline that are going to take time. Dealing with insurance and securing insurance proceeds, that process. Hiring an architect and or engineers to complete the design process and obtain permits for building, and then engaging a contractor and building out the project. All those things can take quite a bit of time. So we want to try to get an idea up front about what that's going to look like. Okay, we can go to the next slide. Okay, so and again, this is sort of high level up front. We just want to make sure that we're appropriately setting the stage for everybody who's participating today. So some of you may have been through construction projects before, and this is, you know, all this and it's simple, but we want to make sure that everybody has this very basic information, right? So these are the potential parties that are going to be involved. There's the homeowner, right? There's the architect and likely the engineers and potentially other design consultants that are going to be involved in producing the plans that ultimately need to be approved that will lead to a permit and construction, right? So, and we'll talk a little bit more about architects and engineers in a minute. And then there is the contractor and their various subcontractors. And they, of course, are responsible for taking the plans developed by the architect and engineers and building the project out. There are the insurance carriers that are going to be involved at the outset and all along the way during the process, during construction. Jason's going to speak to that in a minute. And then, of course, there are the government agencies that are going to be involved either for approval purposes or also for resource consultation. And there's a lot of great information on a number of the websites of the local government agencies and that are involved in these rebuilds. So it's a good time now to turn to insurance, since that's such a fundamental part of the budget setting and the upfront consideration. So I'm going to kick it over to Jason, and I think we can move on to the next slide.
Oh, Tyler, do you want to touch on this slide before we move on?
Oh yeah, sure. This is a bonus slide. Thanks, Jason. Yeah, so this kind of outlines a little bit of what we just talked about, but this is also a really important piece. This is the who hires who element, right? So the most common structure in a construction project is this structure over on the left, referred to often as a traditional design bid build process. This is where you as the owner will engage an architect to develop plans. Then on the basis of those plans, you will go out for bids from a contractor, and you'll separately hire a contractor to build the project. And underneath the architect and the contractor, there will be sub-consultants for the architect and subcontractors under the contractor. And the important takeaway from this is the flow of responsibility, right? Whose responsibility, who is responsible to whom? So under this model, which is going to be the vast majority of the models under which these projects are going to be built. We'll talk a little bit about this other model over to the right in a minute, but the vast majority of them are going to follow this traditional design bid build structure. And you're going to have a contract with your architect, and you're going to have a separate contract with your contractor. And so those two separate entities are going to have an obligation and responsibility to you as the owner to perform their obligations under those contracts, right? The architect does not have a contract with the contractor. So they are both responsible to the owner. Then underneath them, so there will be subconsultants or subcontractors. So the contractor is going to hire general contractors typically don't perform any work, or if they do, they perform very little. They perform certain trades. So on a project involving multiple trades, there will be subcontractors brought in to do the roof or the plumbing or the electrical or the framing. And those subcontractors are going to have contracts with the general contractor, not with the owner. So those subcontracts with the general contractor are going to govern those subcontractors' obligations to the contractor to build your project. Okay. And that disconnect between the owner and the subcontractors is going to come up a little bit later when we talk about liens. But it's important to know the way that these contracts flow and the way that each party is responsible to the next. And I'm going to get into the architect issue in a minute. But for now, think of it as similar to the contractor and subcontractors, where the architect is also going to hire one or more engineers to complete their scope of work. So quickly on this design build model, the only real difference here is that instead of the owner hiring a contractor and an architect separately, the owner is hiring one design builder, usually a general contractor, who has the responsibility to not only build the project, but also to design it. And you may come across this model, but like I said, it's less common. The value here is that you have one party that is responsible for both the design and the construction, and that can simplify communication, it can simplify payment, it can simplify claims if that were to ever come up. And that design build entity will then separately hire either an architect if they don't have one in-house, and also will hire the subcontractors. So we'll touch on this a little bit more as we move through the presentation about who is responsible to whom and who hires who, but this gives you kind of an overview of that structure. So thank you, Jason, for reminding me of that slide.
I know everyone's excited to get to insurance, but I wanted to fit
Yes.
that in there. So next slide, please. Okay, thank you. Hey, good afternoon, everyone. Thank you so much for being here and for having us. My name is Jason Adams. Like Tyler said, I'm our resident insurance nerd. I head up the firm's insurance and risk management practice group. And I don't want to belabor our backgrounds because we have limited time, but just for some context. So our firm's main office has been based in Century City, and starting the night of the fire, our phones started ringing off the hook. We had partners who were impacted. We had clients, colleagues, friends, and we kind of hit the ground running the second this started happening. And a lot of people, insurance is the tip of the spear here. So I, in particular, was kind of at the forefront of this when it all started. Right. So we implemented a wildfire task force at the firm. And now, 19 months later, I've probably helped dozens, if not over 100 people with respect to navigating their insurance claims, largely on a pro bono basis. So we are in the weeds on this. We're doing everything we can to help, and we definitely feel for everyone who's been impacted. And, unfortunately, this presentation is kind of to discuss the second half of this process, the rebuild process. But I understand more than probably anyone that a lot of you guys are still going through the first half of the process, which involves securing your funds from insurance, right? So I'm not going to belabor that first part, but I want to touch on it and kind of level set where you're going to get the funds and how to maximize those funds in terms of the rebuild and how to kind of check the boxes and make sure you get what you can, right? So just in terms of where the proceeds are coming from, as most of you know by now, you're probably relatively far along in your claims. You've got your kind of four buckets of coverage in your standard homeowners policy, right? Your coverage A, dwelling, your coverage B is your other structures, there's ADU, detached garages, things like that. Coverage C is your personal property, and coverage D is your additional living expenses. So at this point in the process, all of those different buckets have been percolating along, and there's different deadlines and different issues coming up that everyone should go back and check their policy and make sure they're maximizing in terms of, are you going to need more ALE? Are you going to be staying out of your house longer while you're waiting for your construction to start? Those are all things to go back and check your policy and make sure you're maximizing, but they're not really directly related to the construction, so I won't belabor them here. With respect to the construction itself, I mean, most people, if you're lucky enough to have coverage in a responsive carrier, you probably got some bucket of proceeds at this point from your coverage A, dwelling coverage, to start to put toward your construction, right? So that amounts to usually going to be based on the actual cash value of your property, which is going to be your replacement cost, what it costs to rebuild, less any depreciation, right? So that's kind of a smaller bucket that the carrier almost says, okay, here we'll start with this. And then if you rebuild, there may be more things we'll pay pursuant to your policy, right? So if you're rebuilding, you may be entitled to more replacement cost value once you start the actual rebuild, right? In your better policies, if you paid an additional premium, usually will have things like extended replacement cost, where you can build, beyond the original scope and be entitled to more proceeds based on a percentage of your recovery amount. And you could have additional coverages like ordinance and law, things of that nature. Just the extra coverages that say if you have to bring your project up to, current code standards or whatever, then we may pay you even more, right? So I assume for most of you at this point, you're kind of floating around in that ether, right? You have some money from the carrier. You're looking, what can I spend? And if I hire someone, how do I get paid going forward to make sure this project stays on track and gets funded, right? So the super high level takeaway as it pertains to this part of the process is similar to what you likely went through to get paid originally, right? It's polite persistence, the polite squeaky wheel gets the grease, right? So documentation, persistence with your adjuster, staying first of mind with the carrier is going to get you a long way in terms of maximizing your recovery, right? So you have a contractor involved. You have a certain amount of money from the contractor. In terms of the nuts and bolts of going forward, once you start construction, you're going to be in the process of generally submitting pay apps or submitting invoices to the carrier, and the carrier is going to consider it, and the carrier is ultimately going to issue a supplemental payment that is going to go to you. And in most instances, there's going to be a lender involved as well. And then once the payment comes in, your lender will look and see if this is a viable cost related to the project. And then the funds ultimately get dispersed, which you can then pay to the contractor, right? So that's the super high level, how it typically works. But as Tyler mentioned at the outset, all of this takes longer than you think it's going to take, and all of it is going to cost more than you think it's going to cost, right? So documenting, persistence, and staying on top of this, it's going to be a process until the rebuild is complete. So in terms of the best big picture advice we can give you here is to stay on top of it, meticulously document all the expenses, submit them early and often, and follow up regularly. Next slide, please. This kind of dovetails to the first slide. It's, a lot of times, the calls I was getting on the first night when the fire happened is, I have never even seen my insurance policy, right? So that's where we started from in a lot of instances. A lot of you are probably far more familiar with your policy at this point. But to the extent you still don't have a copy, which you often have to request expressly, believe it or not, and oftentimes multiple requests. I mean, now's the time, if you haven't already, once you get into these granular issues as to what you're entitled to going forward and what sort of supplemental payments you may be entitled to, it really behooves you to almost become your own semi-insurance expert, right? Sit down and read the policy, read the coverages. The more fully informed you are, the more you can advocate for yourself in terms of maximizing these coverages. And again, document your costs, document your correspondence. If you have a call with your adjuster, send a one-line follow-up email afterward, kind of just summarizing what you talked about. Because as I'm sure what many of you experienced is kind of the revolving door of adjusters, and you may have multiple adjusters on a claim. One adjuster leaves, another adjuster comes in. You don't want to have to start over with the next adjuster, right? So to the extent you can document everything, keep meticulous records. I mean, I feel like I'm beating a dead horse here at this point, but if there's one big takeaway, that's what I want you to remember going forward as it pertains to this small segment of rebuild construction insurance.
And
Next
I
slide.
think, Jason, I was just going to say, I think that that kind of also dovetails into a larger theme of what we're talking about here today about making sure that these things are clear to you, that the process is clear, and that your separate agreements with your architect or your engineer and your contractor, that they account for this process, that they understand the payment process that Jason just described, and that's all factored in to timing and the way that the parties are communicating, right? You want to be open and keep an open dialogue with everybody involved, and you want to be clear in your agreements about what is going to be required. You may have an architect or a contractor that says, we need to be paid, every Friday, and you may have that might not be possible given the way that the invoices need to be submitted through the carrier and the associated lender, and there's a review process to that. So that should all be kept in mind when we're planning this, planning your project up front, and when you're looking at your agreements.
Yeah, 100%.
Okay, so I had mentioned that we were going to talk a little bit more about architects and engineers, and this is going to be not a large part of this presentation because we are going to focus mainly on the construction and construction contract pieces. But it's important that everybody has an understanding of how the architect is different from the contractor and why there are separate engineers, so that this is not confusing or you don't feel blindsided when you hire an architect for X amount of money to design your project, and then they come and tell you that it's going to be this much more money because you need a structural engineer and a mechanical and electrical and plumbing engineer, and that they don't do that. So that structure that I just described is very normal. When you hire an architect, they very, very rarely have the in-house capacity to do all portions of the design. There are separate specialty design scopes that are performed by specialty engineers. So the architect does the architectural portion of your plans. The structural engineer is going to do the structural drawings. And those are going to be separate entities. And same with electrical and plumbing. Often there's some specialty engineers who do multiple, mechanical, electrical, and plumbing, but it's not unusual for there to be an architect and one or more engineers involved in the project. And the way that there's two ways of engaging all of those parties. One is you can hire your architect and have the architect hire those engineers. So you need a structural engineer. Okay, the architect hires that structural engineer, and it's part of the architect's total scope of work in their contract with you to not only do the architectural, but also the structural, and maybe also the mechanical and the electrical and the plumbing. Maybe your architect is going to hire all those engineers. So that's not uncommon. The benefit of that is you've got one person, one entity, the architect, that is responsible to you for all the design. So is it a structural problem? Is it an architectural problem? You may not know. It may be difficult to tell. If your architect is responsible for all of it, then you have one source of responsibility to go to start solving that problem. Now, the downside of that is the architect is generally going to charge a markup for the separate contracts that they hold with the structural engineer, for example. So that structural engineer might be X dollars, and the architect is going to pass through that X plus 10% to you, the owner. So you pay for the benefit of having that sole source of responsibility, but it can be very beneficial. Okay, next slide, please. Okay, so this just outlines the sort of high-level design process. So if you've never been through this, you might say, okay, I hire an architect and I pay them X, and then they produce all the plans, and then I get a building permit and I start building. And that's not wrong, but there's a common process in which plans are developed, and it effectively flows from very little detail to enough detail to get the plans approved by the building department in the city or county in which you're in, and then to have a building permit issued. These different phases of design, the conceptual, schematic, and design development, and ultimately construction documents, that's the typical flow of development. And they're broken up this way in part because at each phase, you will be involved in signing off on certain things and saying, yes, this looks correct, and you may need to sign off from other parties involved for insurance purposes as well, tracking this process. So that's just a quick kind of overview of what the development of the design looks like. Once you get to the end of that line and you've got construction documents, they're submitted to the city or county. They go through a plan check review process, and then to the extent anything is missing or needs to be corrected, they will provide comments back, and your architect should then make those revisions and make those adjustments, and then go through the resubmission process again. And that happens as much as needs to until you get to a point where those plans can be approved by the particular government entity and a permit can be issued. Okay, so let's go to the next slide. We'll talk a little bit about permits and approvals. So what are permits, and why do you need them? So this is the in a nutshell, the governmental process of ensuring that structures are built in a safe way, and that they are built in alignment with current building codes and sufficient processes for the city or the county to ensure that people living in them or using them, if they're not residents, are safe and functional for their intended purpose. So that's a really why permits are required. Not every project needs permits, but the vast majority of the projects that we're talking about are going to require permits. And you can work with your architect to figure out what permits may be needed. And we don't have the time, of course, to go through all the particular nuances of different projects that could occur in LA County, and what different local requirements may be, and are you in the coastal zone, or is there going to are you in which city requirements are going to apply? There's a lot of detail there, and your architect or your engineers can help work through some of those requirements. They should have an understanding of them in the locality in which they work. You can also check with the city or county websites for resources on what you might need and what the application processes look like. And that can give you a sense not only of what you need, but also timing, because these things also take time. There are a number of expedited processes in place to try to get these rebuild projects moving as quickly as possible. The practical reality is that there's a lot of volume, and there's only so much that the local governments are able to process at one time. And so you should expect this to take a fair amount of time. It could be 4 to 6 months or more to get plans through plan check and to get a building permit. And then one last note on this is so your contractor should be the party who actually pulls the permit. And that will include the payment process for the permit. So your construction contract may need to identify how that's going to happen. Are you going to pay directly for the permit? Is the contractor going to pay and then you're going to reimburse them? So that's just a contract nuance here in this last point in the slide. Okay, we can move on to the next slide. Okay, so at what point does it make sense to hire your general contractor? In general, having a contractor on board earlier rather than later can be helpful for a number of reasons. If your contractor is involved before construction begins, they can often help assess what's called constructability, which is really looking at the plans that the architect has developed and identifying practical benefits and impediments that may be there, right? They may be able to say, well, yes, this is one way to do it, but I've done it this way before, and this works really well, and it's faster. And oh, by the way, the materials for that are readily available, and some of the equipment you've got here is going to take way longer to get. So your contractor will have a lot of that practical information about what's available and when, and what are some of the things you might be able to tweak in your project that could save you time and money. And then, of course, you need to work those ideas through your architect if there's going to need to be any changes in the design. But having the contractor on board a little earlier can help with that. Once you've got your plans and your permit, ready to be issued, you can still do those things, but it may just you're ultimately just adding more time because you may have to go back and make changes to those plans and then reprocess those changes under the permit. So bringing that contractor on a little early can be a good way to go. How do you select a general contractor? So you should definitely get multiple bids, right? A bid is just a quote. So a good way of doing that is reaching out to several contractors, hopefully with some degree of design already in hand, right? We talked about those different phases of design development earlier. Maybe you're at the end of the schematic design, which is like step 2 of 4, right? And so you've got a rough idea of what the project is going to be and what it's going to look like. That should be enough to get a sense of what a project might cost from a contractor. The more developed the plan, the more specific a contractor can get when they're looking at it and giving you an estimate. So there's that kind of sliding scale there. There's a sweet spot in there, right? Where you have enough design in place where you know that the contractor, that their quote is likely to be real, right? It's reasonable. There's enough detail in the plans to support it. So definitely get several bids if you can. I know one of the issues that y'all are probably facing is the lack of availability of contractors because there's so much of this work going on. But the best of your ability, if you can get multiple bids, that is going to help give you a sense of whether those prices are reasonable. You can obviously go back and check those against some of your early budget numbers, but realize that they're not gonna cleanly align, right? But if you have multiple bids, then you have a better sense of what the reasonable price might be. You might get 2 that are similar and 1 that's outrageously low, and that should concern you. It's always appealing to see a low bid, but if 2 other licensed, experienced general contractors are telling you it's going to be X and somebody else is telling you it's going to be half that, then you may wonder what are they missing or what's different. And you can ask those questions. You can have those conversations up front. You want to have all those discussions up front so that you know what you're getting into. You should also ask your contractor to provide references, recent projects, and who to contact, and reach out to those references and talk about them and how to go with, get a sense of how they work and whether it was a good experience or not. And then you can review their information on the contractor state license board. there's a way of searching contractors on that website, either by their license number or their business entity name, and it will give you a sense. It'll first of all confirm whether or not they are licensed, whether their license is active, and what kind of license they have. And it will also give some information on their prior, if they have any disciplinary issues or things like that. So that can be a good source of information on checking contractors as well. And I mentioned that you can check their license. This is a really important piece of your puzzle, that your contractors are required by state law to be licensed. Most of your projects are going to require a general contractor's license, which is a B license. And you can check that license on the Contractor State License Board website. There's a link to it right there on the slide. And you want to make sure you avoid hiring an unlicensed contractor. There are a number of potential pitfalls and liabilities that you may come up against if you do end up engaging a contractor that does not hold a contractor's license. And the law on that is pretty detailed. We don't have time to get into all the nuances there, but the takeaway here is make sure they're licensed, check their license on that website link, and make sure that your contract with them is for the same entity that holds that license. It should be exactly the same. Okay, let's go to the next slide. Okay. So in California, there's a subset of projects referred to as home improvement projects. And this is important because almost all the projects we're talking about here today are going to be home improvement projects. And home improvement projects fall under the home improvement statutory scheme in the Business and Professions Code. And what's important for you to take away is there are a ton of requirements that are going to apply to your contract that are aimed at protecting you as a homeowner, right? They're like consumer protection requirements. So a lot of them are going to help you get the clarity in your contract that we want to make sure is there. And I will say that you will likely run into a contractor or two, especially some of the smaller outfits that may not be aware of this. They may not be aware that this requirement and these requirements are going to apply to this kind of a project. And there are a bunch of resources that I have a link to later on home improvement projects and contracts and what's required at the Contractor State License Board website. And so you can go there and check those out too. So we're going to run through a few of them that are important to you and also help kind of educate us on some of the important things that you want in a construction contract either way. So the next slide, please. Okay, so your first one is that your contract's got to be in writing. And I know some of the questions that we've seen are, what about AIA forms? And I work with AIA forms like all day, every day. So they are a great starting point standard form, but they are not adequate for a homeowner to use out of the box. Okay, they don't address any California laws and they don't address any of the home improvement California laws as well. Okay, so they can be used as a starting point, but they are not adequate without some fairly significant modification, particularly for common homeowner protections. So keep that in mind if that's the form you're looking at. Home improvement contracts cannot be on a time and material basis or what's called a cost plus basis. And time and material or cost plus contracts, that means your deal with the contractor is, hey, contractor, you build this and whatever it costs, I'll just pay you. Like every month you tell me how much you spent and I pay it. And you think it's going to cost, $500,000, but if it costs $1 million, I'm on the hook for that as the owner. Okay, it's an open-ended price. There's no cap. There's no guarantee. as they go, they bill you and you pay it. Those are not permitted under the home improvement statutes. So you should get in your contract a defined contract price that the contractor is going to do the work for X amount. Now, a lot of these projects are not easy to apply a fixed price to because they will evolve as they are built. There are going to be things that are unknown. There may be a number of materials or some equipment that is going to be in the house or finishes like flooring that haven't been selected yet. There could be a lot of open elements of the scope that haven't been determined. And so those will typically fall into something called an allowance. An allowance is sort of like a placeholder. It's an estimate of how much that thing is going to cost. So you've got faucets in the scope of work, but you haven't picked out which ones, right? So is it the $25 faucet or is it the $2,500 faucet, right? So those, if they haven't been selected, they might be listed as an allowance, which is a placeholder. And what you should know about that is if the allowance says the faucet is $100, but you pick one that's $250, then you're going to pay an extra $150. So the price is going to adjust based on what the actual cost is. So I have that up here because it's a little bit of a nuance to the whole you can't have a time and material based contract requirement. You may still have allowances, and that's normal, and that's very fair to a contractor because again they aren't going to be able to predict every single cost if it's not clear from the scope. Down payments are not a requirement in your contracts, but if the contractor is going to require a down payment, which is some amount of money you're going to pay before they do any work, it cannot exceed the lesser of $1,000 or 10% of the contract price. So whichever one of those numbers is less, that's the maximum deposit or down payment that you can be required to pay. And in a home improvement project, you are not required to pay for things in advance for work that hasn't been performed or for materials that aren't procured yet. So you should be paying as you go, as the work is done, as things are being obtained. Okay, let's go to the next slide. Okay, I'm going to try to speed up in the interest of time here, but this deals with payment. I mentioned earlier you want to make sure it's clear. There's some sort of sample language about clearly stating how much it is, how much your contract price is. You want to avoid paying with cash. And you want the timing of payments to be clear in your agreement. So there's no dispute over when dollars are due. Okay, we can go to the next slide. Okay, you're entitled to a fully signed construction contract before the work starts. And that construction contract has got to include a bunch of, there are several disclaimers and informational statements that need to be in home improvement contracts that the contractor is responsible for ensuring are in there. One of them is a right to cancellation. So for these kinds of projects, there's a 7-day right to cancellation. So after you sign the contract, you have 7 days to provide the notice of cancellation back to the contractor and say, never mind, I don't want to do it. And there's without repercussion. You're also entitled to a list of all the subcontractors, and it's good to know who's working on your project for lien purposes, and we'll get into that in a minute. Okay, we can go to the next slide. Okay, let's talk about time and schedule. Your contract needs to be very clear about when the contractor is going to start and when they are required to finish. And it's helpful to have a schedule actually attached to the agreement, but if you don't, you need to at very least have the start date and the end date in your agreement. And if you have significant milestones, like elements of the project that are going to occur before it's completely done, that have to hit certain dates, you want those dates in there as well. Okay, and so those dates are not set in stone and permanent. There are typical reasons for them to move, for those dates to be extended. So including any kind of change in the work. So if you decide you want to add some scope of work, then you can expect it to take longer and your schedule is going to get pushed out. Similar with any kind of delay that's really outside of the control of the contractor or their subs. So a delay caused by the owner, a delay caused by a government entity or a utility or some kind of force majeure or weather event. All those things are going to push out the end date of the project. And so you can expect that required end date that's in your agreement to move outward if any of those things occur. We also had a question about liquidated damages, which I don't have time to get into the details of, but just note that that is effectively a per day dollar amount that you agree to in the contract that the contractor owes to the owner if the contractor doesn't finish within the time period that they're required to. So it may be, $500 a day for every day that you don't finish, after X date. They're not required. They will be your only remedy for that bucket of delay or that bucket of damages if you have one in your agreement, but they are common.
Yeah, if I can just add something, Tyler, I think
Yeah.
this is a provision that a lot of people may not be familiar with, and I know it's an uncomfortable situation discussing with a contractor. You've probably all had an experience where you hire a contractor to do work on your house, and you get the contract signed, and then they disappear, or they send out the B team, or whatever it might be, and you look at your contract, and it doesn't really have a firm date when the project needs to be completed or a duration in which it needs to be completed. This is really, really important in this context because not only considering the fact that what we were talking about, a lot of these contractors are going to be extremely busy and jockeying between multiple projects. There's a whole host of other reasons why they would not stick to schedule. And if there's no contract provision that requires them to stay on schedule, they will not, because there are no repercussions. And the only remedy you will have in the event of of what you might call a delay or just taking too long is you would have to prove that it was an unreasonable delay, whatever that might mean. And then you would be able to terminate that contractor. That probably doesn't get you what you want. So make sure you have a contract provision that sets the duration, the time, and then like Tyler was saying, liquidated damages, they're nice because me being a construction litigator, you then avoid the obligation of having to prove up your actual delay damages. So what you do is you just say, well, it's delayed, 35 days. We agreed that it's $2,000 a day. You do the calculation, and that's the amount that the contractor will owe you. So it limits the litigation expense. So it has multiple benefits. The only thing, and it goes down a little bit of a rabbit hole, but the only thing that I would say is it can't be arbitrarily set. The liquidated damages per diem have to approximate or be based on what you anticipate at the time of contracting your actual damages would be. There's a code section that says if it doesn't do that, they throw it out. Right. If it's unreasonably high and constitutes a penalty, the court will throw it out. So anyway, just wanted to add that. Thanks, Tyler.
Thanks, Rob. Yeah, that's all good points. And that's, there's quite a bit of nuance in a liquidated damage provision. But yeah, they can be a good tool. Okay, let's go to the next slide. Okay, so continuing on the elements that you want to make sure are in your construction contract, you want to make sure that you're getting mechanics lien waivers, and those should be provided by your contractor and their subs with each invoice that they provide you. These are statutorily driven forms. They need to be substantially in the same form as the civil code statute in which they exist. So you need to use the correct forms. You can find them on the Contractor State License Board. website, and there's a link here to that as well. But you should be getting those with each invoice that's submitted by the contractor. And we'll talk a little bit more about mechanics liens in just a second. I'm going to kind of move through a couple other considerations real quickly that you want to look at in your agreement. There should be a change order form. That's a requirement in the home improvement contracts. And then there's another link here to a number of other elements that need to be in these contracts, and as well as what we've talked about today. So if we can go to the next slide.
Hey, Tyler, if I can jump in, I can't remember if it's
Yeah.
in the next slide or not, but change orders have a provision in your contract that requires written change orders signed by both sides. If you do not have that, you will have constant bickering between the owner and the general contractor about what was approved, what was not approved, what the price of that change was, et cetera, et cetera. Put a provision in your contract that requires change orders to be in writing.
Yeah, great point, Rob. And it's not in these slides, but there is some statutory language about changes and change orders and home improvement contracts that you can find on the Contractor State License Board list of provisions that need to be in these agreements. That'll be a great resource when you're looking over this contract to see, does this check the boxes of everything that I'm supposed to have in this agreement that are there for my protection? Okay, so real quick before we talk about liens, just want to make sure that it's very clear what the scope of work is. So your contract should have a reference to the specific dated stamped plan set that the contractor needs to build off. That's going to define your scope of work. That needs to be clear. Retention is not always going to come up in these agreements, but it's a very common provision. It's effectively the owner's ability to withhold from each payment that's otherwise due to the contractor some percentage of that payment. Those amounts get held to the end of the project, and then they're paid to the contractor at the very end. So it's a bit of like a safekeeping of amounts that are already due to the contractor that the owner holds on to until the end to make sure that the project is fully completed. Lenders, if there's a lender involved, you need to name them in the agreement. And as Jason mentioned earlier, make sure that the contracts all reflect the lender requirements and the carrier requirements, especially in terms of payment and payment timing. Okay, we can go to the next slide. Rob mentioned termination. You need to make sure that your agreement gives you the ability to terminate for cause. That means for a reason, or for no reason at all. In the event that you need to just get out of the agreement. Contractors can typically terminate for cause, but not for their convenience. You want to make sure that you've got a warranty provision in your contract that where the contractor is warranting to you that the work that they're doing is of a certain quality, that it meets the plans and the contract requirements, and it's done in a workmanlike manner, in a good manner. You should also get manufacturer warranties for any equipment that's installed. And there should also be a provision that requires the contractor to come back, usually within a 1-year period after completion, to fix any defective work. And then bonds. A bond is, we could spend all day on bonds. A bond is effectively a third-party guarantee of the work. So it's something the contractor performs that provides that effectively says, hey, if this contractor doesn't complete their obligations, we, the surety, which is usually an insurance company, will step in and make sure that the obligations under the contract are fulfilled. Bonds are not common in these types of projects, but they can be requested. They will cost you more. Usually 1 to 3% of your construction contract cost will be added in order to pay for the bonds. Okay, the next slide, we're going to touch a little bit on just some of the typical, and I know we're basically at time, but Nisa, is it okay if we keep going?
Yes, absolutely. This is
Okay.
really helpful.
Okay, thank you. I apologize. I know there's so much to get through, but so I want to give Jason a minute to talk about the typical insurance that you want to make sure that you have from your contractor and on your project.
Thanks, Tyler. Yeah, so I could spend an hour on this slide alone, right? But I'll try to burn through it at a super high level to give you my takeaways. So I understand you're reviewing these contracts. Insurance doesn't always seem like the most important provision, right? You're looking at the price, you're looking at the scope of the work and all the construction related stuff. But in the event something goes wrong, insurance quickly becomes the most important provision, right? Especially depending on the size of your project, the viability of your contractor. If something goes wrong and your contractor's out of business at the end of the day, then you may be limited solely to recovering from insurance, right? So it becomes a super important provision if anything goes wrong. So there's two ways to drill down on this as much as possible, right? So the first way is to make sure that the contractual requirements are clearly articulated in the contract. And then the second way is to make sure that whoever's supposed to get the coverage set forth in the contract actually goes out and secures that coverage, right? So I'll talk briefly about both of those. So in terms of step one, making sure the right contract is the right insurance is in the contract. Every contract you're going to get, as Tyler kind of said previously, is going to be based on this home improvement contract, right? So as it says in the first bullet point there, the contractor will have to procure commercial general liability coverage, your CGL coverage, and workers' compensation coverage. So the question then becomes, what are the adequate limits? What kind of form does a contractor have? Those are all nuances that you can greatly enhance with some negotiation typically. And that'll depend on the size and difficulty of your project. So if you have a massive project, you want more limits, you want better coverage. That's the high level takeaway there. So in addition to those base coverages, there's also just a litany of other coverages you can obtain for your standard construction project. Those oftentimes won't be volunteered by the contractor, but you may want to insist on them depending on the project, right? So the first of that would be your builder's risk insurance. That's typically called course of construction insurance, right? So your contractor's CGL policy may not provide coverage for work while it's under construction. They may look to a separate type of insurance called builder's risk insurance to cover that risk. So that's a primary gap you want to look to see if you have to fill. Sometimes the owner can go and procure it, and sometimes the contractor will bring it. But it's an issue you want to drill down on and have clearly articulated in the contract. And then depending on the project itself, especially in these fire damage instances, there are supplemental lines of coverage like pollution, for example. Is there fire damaged soil or contaminants that may be released as a result of the construction? If so, that's a potential pollution exposure. Should someone be getting coverage for that, right? And if so, how much? And similarly, there's a litany of others as well. Is the contractor undertaking a bunch of design elements where you may want professional coverage, right? So the point is every project's different, and these insurance requirements are negotiable. And owners should carefully consider what is needed on the project and maximize whatever coverage they can get from the general contractor. And it typically costs more, right? But this is one major area where an ounce of prevention equals a pound of cure if something goes wrong, right? So it's a discussion that should be had and that is super important. So that being said, you get the best insurance requirements possible in your contract. It doesn't do any good if no one goes and gets the right coverage, right? So that's the follow-up you also have to undertake. Your contractor is most likely going to provide you, pursuant to the contract, what's called a certificate of insurance. That's basically just evidence of coverage, evidence that a policy existed on the day this form was generated by the broker. It's not formal evidence of coverage in the event something happens, right? That only the policy itself binds coverage and dictates what the carriers are going to do, right? So to the extent you can, try to get copies of the actual policies or critical endorsements to confirm that you're getting the coverage that was specified in the contract. So I could talk about this all day. There's certain key endorsements you want. You want to be named as an additional insured on the policies. You want the contractor's policy to be primary and non-contributory to other insurance policies. You want a waiver of subrogation in your favor so the contractor's insurance carriers aren't looking to your insurance carriers in the event of a payout. This gets super nuanced and I don't want to go too far down the rabbit hole, but from a high level perspective, get the right coverage in your contract, maximize the limits, maximize the forms, check for any problematic exclusions, and then make sure that coverage is actually secured.
Great. Thanks, Jason. And then lastly, I want to make sure that we circle back on the mechanics lien and those that nuance and those requirements. We spoke a little bit earlier about how you want to make sure you've got lien waivers as part of your payment process. Those lien waivers help waive the contractor's lien rights for the amounts that they're requesting in that payout. But I want to ask Rob to kind of talk a little bit about the mechanics lien process and what that looks like, and maybe if
Sure.
we've got time, some of the claims issues as well.
Sure. Next slide, please. My colleagues have left me with about 2 or 3 minutes of time here.
Sorry.
Jam me up like that, huh? I'm kidding. All right, mechanics liens. First of all, it's wrong nomenclature. When you hear the term mechanics lien, don't think of an auto body shop. Think of these are contractor liens. And a lien, what is a lien? A lien is a security interest that a contractor will impose against your property. So they record in the recorder's office a document entitled mechanics lien, and it imposes a security interest against your property upon which they can ultimately foreclose if they prove to a court, through a lawsuit that they're entitled to this money. All right. So what happens is, let me kind of take everyone really quickly through the process. You hire a general contractor. That general contractor hires a number of subcontractors that you may or may not know who they are. Those subcontractors are required to serve the owner with what's called a preliminary notice. At the top, it'll say 20-day preliminary notice or just preliminary notice. All that means is it tells the owner what subcontractors are working on the project and will have lien rights. Without a preliminary notice, nobody will have lien rights against your property. So keep those. Don't throw those away. Those are good to know, good to have, and good to know who may have lien rights against your property. And as you are being billed on a monthly basis, generally from the general contractor will submit with the monthly pay applications the what are called conditional lien releases, lien waivers of each subcontractor. And it basically says, if you pay this amount, owner, you will release the lien rights of the subcontractors to the date that's in that conditional release. Okay. So it's just part of the process. You will learn. Here's the power that a contractor has against your property is that in the event that you do not pay the general contractor, for example, because maybe you think he did shoddy work, or maybe he has delayed the project so immensely that you would have a delay claim against them. They will then the general contractor records a lien. Also, the subcontractors record a lien. So there's like a double lien on your property. And that's a cloud on title. So you cannot sell your property without satisfying those liens. And then and I don't want to go down that rabbit hole. There's ways to get those liens released absent waiting, the 2 years that it may take to litigate the subcontractor's lien cause of action, the foreclosure of lien cause of action. Let's see. I think that probably covers it. If I go down any further rabbit holes, it's going to take more time. Next slide. Okay, how to avoid mechanics liens. Again, get the lien waivers with each invoice as we discussed. Another preventative measure that, if possible, it really is a good idea is to do joint checks. So as you're getting your monthly pay applications, traditionally what the owner does is the owner will pay the general contractor. And that by paying the general contractor, that general contractor can take your money and just run away with it and never pay their subcontractors. And those subcontractors will still have lien rights against your property. So if you do joint checks, and a joint check is basically a check that is made out to both the general contractor and a particular subcontractor that then requires both signatures, and for the money to ultimately make its way through to the subcontractor so that when he receives that money, the conditional lien release that he provided is effectuated and effectuates a release of their lien rights. A lot of people don't do that because it is sort of an administrative headache. But it is if you are contracting with a general contractor that you do not believe is solvent, or you do not believe is, has the money to pay subs, you got to do it by joint checks just to protect yourself. All right, what to do if a lien is recorded against your property? That is probably where you call up an attorney, because you don't want to handle that on your own. But there is this, and what your attorney may tell you to do is procure a lien release bond. And what a release bond does is, and it usually costs about 1 to 2% of the amount of the subcontractor's lien. That's the premium that it costs. And it releases the lien from title, and it basically says to the subcontractor that records it, okay, you don't have a right against the land anymore. Go against the bond. You have to sue the surety that issued the bond. So it's kind of like buying insurance, but it's different in that if the subcontractor is successful is successful against the bond, proving its payment claim, you will be ultimately liable to pay that amount. So, but it's a quick and fast way of getting the lien off of title if you need to, for whatever reason, the lender requires it, or you're selling the land, or whatever. So, next slide. Claims and disputes. All right, most construction claims. Yeah, most of it's funny. I've been doing this for 23 years. There is a typicity to owner general contractor litigation, right? So usually it's contractor sues owner for not paying a certain amount. Owner then cross complains against the contractor and says, I didn't pay you because either there were the following defects, and or there were the following delays, or there's a fight over scope. The contract wasn't clear enough as to what scope was included in the contractor's scope, and the contractor says, nope, this was extra work, and the owner says, no, that's included in this language, and so then there's a fight over that. So there is like I said, there is a typicity to the types of construction disputes, and those are, for lack of just lack of time, those are the main types of disputes. Include language in your contract. This is important. And one thing that I don't know if is in this slide, but in addition to adding to your contract the forum in which you will litigate your construction disputes, and there's essentially two main forums. There's litigation, means in the courtroom, or there's arbitration. And for those not familiar, arbitration is it's similar to litigation in that but it's a private hired judge. And there's like the rules of evidence are more relaxed. You basically go to a conference room. The arbitrator is the decider of the fact and the law, and you try your case in front of the arbitrator. It's beneficial for several reasons, especially in the construction world where most judges don't understand construction law. They will not understand delay analysis, which is very complex, but the arbitrator that you hire may understand it. So there are benefits, there are pros and cons to arbitration litigation, something you want to consider when you're entering into your contract. But the other thing that I'm not sure is included is an attorney fee provision, a prevailing party provision, something that's very important. And one of the first questions I ask whenever I take on a case is, in the contract, is there a provision that says, if you win, if you are the prevailing party, can you recover your attorney's fees? And as you know, attorneys are expensive. And sometimes the amount that you spend on your attorney to litigate a matter eclipses the principal amount of the claims. So you may have a claim for $100,000. By the time you get through trial, you may have spent 300,000, and that doesn't make any financial sense. Even if you win, you sort of lose. So, but there's pros and cons to that too. But I usually urge people to at least consider having a prevailing party provision, or what I call an attorney fee provision, in their contract. Okay, next slide.
Yeah, so I mean, as you can see, there's just a tremendous amount there, and apologies, Nisa, for taking us over, but there's a few resources here for additional information, and of course, we encourage you guys to reach out to LAFLA and your local government websites as well for additional information and resources.